Right, so this is LAWS 12066 Land Law, and this is the lecture for topic 8 on social housing. Now folks, this is a different type of topic to be included in a land law course. As you know, we here at CQ are a bit groundbreaking, and I in particular like to be innovative and challenge boundaries around areas of practice and knowledge that I think are important for my students. And you've seen examples of that already in both the Term 1 course and in the land law course, especially with regard to the evolving context of technology. A land law course, and up until now, has been very much focused on the rights and the obligations of private freeholders, and in Queensland that means Torrens title holders, and other interests that can affect the registered proprietor's interest, leases. We've seen mortgages in the context of the Torrens system. We're going to see the role of the law of mortgages as the last topic in this unit. That's important because of the property law rights that arise through the mortgage, which is the security mechanism with regard to funding land transactions. But this topic is different because it's moving us away from a central focus on private freehold, even though, as we'll see in the lecture, there is opportunities for private ownership emerging in the social and affordable housing landscape. But this is really about the accommodation environments, the dwelling environments, and the land environments of members of our community that are arguably socially and economically disadvantaged. That's the section of the community which social housing and community housing reaches out to. The emergent idea of affordable housing has arisen really as a consequence of the fact that a lot of Australians are being locked out of the property market in terms of private ownership, private freehold. So other options are being explored, including with government assistance and so on. The main focus of this topic is to introduce you to social and community housing, with some comment on affordable housing and some comment on the reforms and the regulatory arrangements that are in place, including the current policy strategy in Queensland under the Housing Policy Strategy 2017 to 2027. Now, just make a note of that replaces the 2020 strategy, which I refer to in the notes. It's a more recent policy strategy, and I put that up on the Moodle website for you. It's important to be aware of that, folks. The Queensland Housing Policy 2017 to 2027 on the Moodle website. So without further ado, we'll just share the slides. Right, so social housing as part of land law. Not a usual topic that comes up in land law for students at other law schools, but we like to do things a bit different here at CQ. And I think it's an important and an emerging area that property lawyers need to be conscious of, because this is an area that needs property lawyers. It needs their expertise, it needs their understanding. Increasingly, there are more complicated situations arising in this space that require property law guidance and advice. Right, so what are we doing? We are giving some thought to the historical perspective around the emergence of social housing. We're asking, well, what is community housing? How do we understand what that is as a concept? We want to look at the proprietary interests in social housing properties. It's a land law course. What are the land law rights and obligations and entitlements in this area of dwelling habitation, if we can put it like that? we need to understand that we have a national framework, a national legislative framework, the Community Housing Providers National Law, that was introduced to provide more robust regulation in relation to those that were managing community housing stock, but it also makes provision for access to community housing in various ways. It's not just about the regulation of those that manage community housing. And one of the things about this is that it is a national framework, but it's not legislation that's been enacted by the Federal Parliament, but it's arisen as an agreement through the strategy of housing ministers, state-based housing ministers. So they've come up with this national law strategy, a bit in the same way that, for example, has happened in electronic conveyancing. And then it has had to be implemented and legislated in the various jurisdictions to achieve the force of law. And it has been enacted in several jurisdictions, but not in every single jurisdiction. And it has been enacted in Queensland, which is important, but not through separate legislation. Different states, territories have taken different views about how to enact the national law, where they've decided that's what they want to do. And we find that in Queensland, the Housing and Other Legislation Amendment Act, which was passed in 2013, is actually an amendment to the Housing Act. And I'll show you the relevant portion of the Housing Act shortly. So it's the Housing Act in Queensland that we're concerned with, the Housing Act 2003, that's been amended by the 2013 amendment, that has incorporated provisions dealing with community housing, as we'll see shortly. And just to have an awareness in this space of the residential tenancies and rooming accommodation legislation, that's the Act 2008, Queensland. Discuss that in the context of leases just briefly, because obviously it comes up in that area with regard to residential tenancies, but we really didn't go into it. We just brought it to your attention, aware of it. But our focus was, as you know, as I discussed in the lectures, around the general law framework governing leases, mostly commercial leases. We just touch on it here because, again, we're not going to go into it in any great detail, but it's the framework that actually governs the rights and responsibilities between the community housing provider and the community housing tenant. And almost entirely, community housing tenants are subsidised tenants by the government, so they're paying subsidised rents. The government is also funding the sector in terms of organisations that are managing community and social housing stock. And also in some jurisdictions today, there is the availability or the opportunity for community housing providers, which are community-based organisations and incorporated organisations, to actually purchase public housing properties and to then make those available to their community housing tenants as the owner of the property from the government of the day, purchasing community housing, public housing dwellings from the government of the day. And they're also, community housing organisations are getting more involved in the affordable housing space by mechanisms of being able to leverage finance into the sector to raise loans to actually purchase properties and start to get a bit more involved in that sector. But that's something a bit larger, but just have an awareness of this environment of, basically these are strategies to try and deal with the housing crisis for, firstly, those that are in circumstances of economic or social disadvantage or challenge, and then those, in addition, that are struggling to be able to access the private ownership market. There's another dimension as well, which we won't, another couple of dimensions actually. There are often specific strategies dealing with Indigenous Australians because of the particular challenges which they have. And we'll see when I refer to the housing strategy in Queensland 2017 to 2027 that there's a particular focus on that, and there often is. And there is a further strategy that has been developed by the Commonwealth and is administered very often through state agencies, but also with community and charitable organisations, and that is emergency housing for those that suddenly find themselves without any housing at all. So we're not going to go into that. Our focus is going to be on social and community housing primarily, but just that's a broad picture of the landscape. One of the ways, so we've got just some key terms there, social housing, tenant housing, and so on. So one of the ways to get a bit of a picture of the landscape here is this nice infographic. Now, this is from the Productivity Commission's report 2016. Productivity Commission puts out reports on government service annually. And this is I've taken this one, I mean, they've had subsequent reports there, but this was a very nice infographic. And it's quite recent. So that's useful. So it's showing you housing, I'm sorry the top bit's a bit cut off, but it's showing you housing assistance in Australia. So that's basically, I mean, housing assistance being provided by the government of the day, by the Commonwealth in this case. You can see there's a reference there to the Australian Institute of Health and Welfare. They also have a focus on housing assistance and do analyse data and the nature of funding and the nature of experience, satisfaction of tenants and so on. And what's interesting about the infographic is it just gives you a bit of a demographic around, well, who is it that's being housed? How many dwellings do we have? So, for example, in 2015, there were approximately 818,000 Australians living in social housing. Now, that's out of a population of what in 2015 might have been about 22, 23 million. So nearly 1 million people living in social housing, right? And then you can see that little pie chart which shows you the breakup of the different types of housing. And if you come across to this diagram here, or the sort of like the table, it's showing you that you can have public rental housing, you can have state-owned and managed Indigenous housing, which I was just referring to a minute ago, mainstream community housing, which is mostly what we're focusing on, Indigenous community housing. So there's two types of assistance there for Indigenous Australians. Commonwealth rent assistance, that's a form of the Commonwealth providing funding to assist with private rental accommodation, private rent assistance schemes, and other types of programs. And you can see also that there's some other information there so on the first column you've got the number of Australians in social housing. In the second column you've got the number of social housing dwellings at 2015. So about nearly 500,000 dwellings, right? And then you can see the breakup between the different types of housing. And but interesting under that, but in 2015 there were 200,000 households were on social housing waiting lists. 200,000 households. So it is quite important and significant in my view for lawyers to have an awareness of this area. Those that have an interest in working in this space or assisting in this space, just to have an understanding of the landscape and the property law dimensions and so on. And there is a need. There is a need for property lawyers to be in this space in various ways. Not always operating in totally conventional situation, that is on a fee-for-service basis, but in various ways. And if you've got an interest in this area, then I certainly strongly encourage it, because it's also an area of interest of mine, research area of interest of mine, and more widely. And of course, this can come up in assessment, as you will have seen. And these arrangement of the landscape and thinking about the information, thinking about not just the legal structures, but policy initiatives and reform initiatives, very important when you're thinking about this area in terms of assessment, because that's all in the mix. Now, we also need to appreciate that the legal structures and the legal environment in this area is governed by both Commonwealth and state-based legislation. At the Commonwealth level, there is both mechanisms around trying to provide structures for funding. So the National Rental Affordability Scheme Act was introduced by the Rudd government in 2008, which replaced the Commonwealth State Housing Agreement legislation under Housing Assistance Act, Federal Housing Assistance legislation, Commonwealth State Housing Agreements, which existed since the first agreement, which had been entered into by the Chifley federal government in 1945, post-Second World War, and set up a 10-year program of public housing. It was a transformation, really, in Commonwealth government support for this. And that really lasted, Commonwealth State Housing Agreements, CSHAs, lasted right up until the reconfiguration of this scheme under the Rudd federal government in about a year after that government was elected. There's also income tax provisions within the income tax legislation, just to have an awareness of in terms of how that works. And then there's also regulations with regard to national rental affordability. And then in Queensland, we have the, as I said at the outset, with the Housing and Other Legislation Amendment Act, which is amending the Housing Act 2003 Queensland, and then we have the residential tenancy legislation in Queensland. We also have, as I mentioned before, specific legislation that's been introduced with regard to community housing. We've got the Community Housing Providers National Law, and we've got, that's just some examples there of how it's been implemented or adopted in other jurisdictions. So that national framework has been adopted in other jurisdictions in various ways. Okay, so just before we get on to that, I just want to come back to, just I'm going to stop screen sharing that for a moment. So I'm going to now just show you the legislation. So this is the Housing Act 2003 Queensland, okay? So the Housing and Other Legislation Amendment Act 2013 amended this act to incorporate which became an incorporation of the 2003 Act, Part 4 capital A on community housing providers. Now, you can see, just scroll down there, that basically it sets up framework. What do we mean? What are the definitions? Setting up a regulatory framework here, establishing a registrar, registration, enforcement powers, and so on. So that's Part 4 capital A, which is dealing with community housing, essentially mostly with the regulation of community housing. Just stop screen sharing that, and I want to show you something else. So in terms of the regulation of the sector, we also now have the National Regulatory System for Community Housing, and I've given you a link on the Moodle website to the NRSCH website. This is a national body or national regulatory grouping, and you can go in there and you can see, what's going on and the circumstances in the different jurisdictions. So you can see there, I've followed the links to Queensland. So we have the Queensland legislation, which I've already shown you. We have policy position with regard to Queensland. We have, importantly, this idea of the separation of policy and funding decisions from regulatory decisions. So this was something in the background of community housing that was quite mixed. Often you had, before specific legislation was introduced dealing with community housing and the regulation of the sector, what we had was basically executive government decision-making that was affecting everything: funding, policy, regulation, and it was all mixed in together. And it was very challenging because essentially community housing organisations that were managing community housing stock were, and the sector generally was dependent on government funding. So everything came back to that funding source. The other aspects of the environment and control tended to get lost within the funding funnel, if you like. And even the idea of property rights. So historically there were, put in place leases with regard to public housing properties that were being managed by community housing providers, but so there had to be sort of a head lease arrangement put in place. But that was quite, in a sense, nominal, and the parties hardly ever referred to that. It was mostly, they went back to the funding agreement. So it was quite sort of dispersed and diluted historically in terms of working out the different mechanisms of control with a heavy focus on funding. Well, that's been separated under these changed arrangements. And again, this is in the NRSCH website. So Queensland definition of community housing assets, right? Reference there to the Queensland, the Housing Act of Queensland, and so on. What is covered by the legislation, and what are assets within community housing for the purposes of regulation and the coming under this legislative environment. Right, so I'm just going to stop screen sharing that and go back to the slides. So I've just also previously pointed out to you the fact that there are examples, and in the notes you can have a look at, I've given you information there about how it's been adopted in other jurisdictions. New South Wales has been a bit of a trailblazer in driving forward the changes. It's actually developed its own legislation separate to the housing legislation dealing with community housing, and it's been quite significant in various ways, but other states and territories have picked up and moved with the reforms. So what are we talking about when we're actually identifying community housing? Okay, I can suggest to you that the essential features of community housing reinforce what I would put forward are the key characteristics of social housing. But firstly, we have a not-for-profit housing landlord that's concerned with both asset and tenancy management. So historically, these organisations which grew out of the community sector, and they were not-for-profit, so they were not in the business of making money, in a sense. They were in the business of providing appropriate accommodation options for members of the community that didn't have accommodation. And going right back to the origins of community housing, the truth is that it, in many jurisdictions, it often grew out of the need for persons that have been traumatised in circumstances where they were maybe in a relationship, and very often was women that were subject to domestic violence by their partners, by their husbands, and there weren't enough options. And so it started with that sort of response, saying, look, there needed to be something more here. And then it expanded from that, realising that, well, look, there's a broader range of people that have a need for housing who can't find regular housing or are falling out of the regular housing situation for various reasons. And over time, this has also included young people that, again, can't find housing options or alternatives. It's interesting when you go back to the infographic. I might do that for a sec. Just go back to that infographic that I showed you before, so that you can see there in community housing, apart from the fact that it says it's doubled since 2008, which is an interesting statistic itself, 62% of main tenants are women. 62%. And there can also with dependents, children. So it is still continuing to serve that group within the community of members of the Australian society that are suffering from economic and social disadvantage, or indeed, in truth, continue to be victims in various ways of circumstances of life, including circumstances that come out of the horrendous implications of domestic violence, sadly. So we just come back to that. So it's very important that, you know, that these organisations are community-based and they're focused on providing assistance to those in the community who are challenged in terms of housing options. They're not for-profit entities. Historically, they were not. There's some of those moved into the affordable housing space in different ways. And this was actually one of the things that over time, as the organisations got larger, they needed to have more professionally trained individuals that were part of their management committees and needed to do things in a more business-like and professional way, particularly in terms of accounting for monies and how that was expended and resources and so forth. And that was part of the regulatory response to the sector as well, which the National Regulatory Framework tried to respond to. So the second characteristic here is a focus on the social purpose of building and strengthening social capital by encouraging community involvement in the project. So it's sort of like it's a grassroots response to the issue, and that this is an important social interest and social concern of the community. Thirdly, that there's broader tenant choices through better integration of household needs with dwelling capacity and amenities. So a response to, well, okay, we're dealing with people of social and economic disadvantage. What do they actually need? And in more recent times, this has actually been about providing different types of dwelling options, given the nature of those that are being housed. And that's, you know, we went through a period where the style of housing was standardised. That has changed, and now we're developing something more responsive to the needs of those that are being housed, including that those decisions being undertaken not by large state government bureaucracies, departments of housing, for example, if they still exist as standalone, but often they've been amalgamated into, you know, bigger super departments, but actually by these community organisations, not-for-profit organisations that are closer to the tenants, closer to the ground, closer to the needs that need to be met. And then lastly, which is an important feature, is that we have tenant participation in social housing landlord decision-making. So that's very different to private rental accommodation, okay? So as we saw in the topic on leases, we don't find that the tenants are helping to make the landlord's decisions. It's landlord versus tenant, or lessor versus lessee. And in the private rental accommodation governed by residential tenancy legislation, that's the case of landlord and tenant. But in social housing, where you've got the housing stock being managed by a not-for-profit community-based organisation, the tenants that they are giving accommodation to have an opportunity to participate in the decision-making of the committees of these not-for-profit organisations. So that's actually quite different. And it's an opportunity for them to have a say in the sort of decisions that are impacting upon the housing which they can access. And the idea and the nature of community housing has evolved over time a bit. And again, I've referred you to the infographic from 2016 Government Service Report. You can update that further by going to, I don't know, I'm just at least the 2018 Government Service Report. We might be a little bit early for the 2019 Government Service Report, but emphasise good to have current understanding of policy, particularly if this comes up in an assessment context. Good to have current understanding of current policy strategies, both by the Commonwealth and also by the Queensland Government. I'm just going to show you shortly just exactly what Queensland Government's doing through its housing strategy. So there's a bit of a statistical overview. I showed there was one a bit earlier with regard to 2015. And again, this is updating more recent 2018 reports by both Productivity Commission, which has a dimension focused on housing assistance as a government service, and also the Australian Institute of Housing and Welfare, which has a focus on housing assistance across Australia. So that you can see there, for example, community housing, we had 75,000 households, or 75,500 households, and nearly 83,000 community housing tenancy rental units, and then other combinations of those. But we're mostly focusing, just in thinking about these arrangements, long-term community housing and the regulation of that. But it's important to get an overview of the situation, and also public housing, which is was the first response by the governments of the day to deal with members of the community not being able to access private accommodation, private ownership or private rental. Then public housing was provided, and you can see there the number of households and the number of dwellings. But over time, it's been realised that whilst public housing is still a feature of the landscape, it's often the case that these large bureaucracies, these housing departments and so forth, can't make the best decisions and provide the best options. And so increasingly there's been an emphasis on community-based organisations managing the stock, and I think it's fair to say they often do a better job, and they certainly are more in touch with the needs of their tenants. So it's important to appreciate the roles of different levels of government, Commonwealth as opposed to Queensland. And I mentioned earlier that we have historically the Commonwealth State Housing Agreements, which went from 1945 post Second World War to 2003. I said that we had the new reconfigured agreement structure in 2008. What happened was we had a renegotiation, because these were agreements that were negotiated between the Commonwealth and state and territory governments. And we had one in 2003 by the Howard government, which actually then continued on until the Rudd government was elected in 2007, and that's when they instituted the reconfigured scheme. So you can have a look in the notes about the historical background, and the launch of this back in 1945 was arguably quite revolutionary, in that we introduced a 10-year public housing plan under the Chifley government of the day, and it was simple, it was pragmatic, and it lasted for 10 years. And so it was a big shift in housing policy. You can see that there is also some discussion about the way in which that emerged over time, that there was a shift away from public to welfare housing, and a focus, for example, just picked up a provision there in the 1996 Housing Assistance Act. So the Commonwealth introduced some changes over time through its legislation. So in Section 4 of the 1996 Commonwealth Housing Assistance Act, we had a focus on to target housing assistance to those most in need, including the homeless. By the time we got to the Hawke government, federal government, which lasted also for a decade, in the 1980s, there was then a focus on community housing, and under the Commonwealth State Housing Agreements, an introduction of a special program and that was the beginning of a focus federally on community housing. We found that there was a waxing and waning between federal governments and conservative Liberal governments, so that federal governments, federal Labor governments, more focused on provision of housing, public housing, and providing support and funding for that. Conservative governments were more concerned with giving people options, letting them purchase public housing if they were able to do so, finding other ways that were consistent with their values and philosophies. And so we had this waxing and waning over that almost half a century, a bit longer. And you can see that there's just a few comments there with regard to the underlying values and underlying purpose in terms of what we're trying to achieve here in terms of developing this sector, developing community housing. It's also important to remember that the CSHA was a political agreement. It wasn't a legal agreement. It wasn't a contract, okay? And that's different, okay? Even though it was set out in a way that sort of in various ways looked a bit contract-like, but you couldn't actually take the Commonwealth to court and sue them, right? States couldn't do that. But there were other things that could be done. But the other thing that occurred over time was conservative federal governments increased more and more performance mechanisms, because basically what's happening here is the Commonwealth is funding the sector and the states were administering the sector, and that's often what's going on in our Commonwealth-state relations in our federation, because the states and territories don't have the capacity to directly fund, to raise taxes, as we know. So that's the Commonwealth, and they're directing funding, and they can often, it can be tied or it can be specifically targeted, and then they're requiring accountability and performance mechanisms, and then state agencies would pass those down to organisations that were actually administering or, sort of managing the housing stock at the end of the day. And this is where we ran into some hurdles, because those increased financial accountability mechanisms on not-for-profit community organisations that didn't have the level of professionalism and business focus started to stumble a bit. And that's where we ended up with the new regulatory system. So as I mentioned earlier, we've got the new arrangement, the new structure that was introduced by the Rudd federal government as part of its re-looking at the Commonwealth state federal, the Commonwealth state federal relations, and then it introduced the National Affordable Housing Agreement and National Partnership Agreement on Social Housing. But there's been adjustments to that over time by subsequent governments, as we're now, about a decade on from when this was first introduced. You can go on to the Commonwealth website. That's the, essentially it's like a mega government agency. Right, so I can just show you that website for the Commonwealth. So basically, this is the Department of Social Services, and over time, this is, there's been reconfigurations of government agencies and so on, as there is, so that we've now got a section within the Department of Social Services, or DSS, that focuses on housing support, which is actually, it's wound back its degree of focus on this area, and that's another trend within conservative governments, is that this is not something that it pours a lot of money into or ratchets up the focus. It tends to look at other options and other ways in which the private sector might be involved, or how we might deal with these challenges. We can see there that from a policy perspective, the Commonwealth, in terms of housing support, focuses on housing on the one hand and homelessness on the other, and I just differentiated that initially. That's emergency housing and responses today, not historically, to domestic and family violence and so on. But if we just go to continue on to the housing option, what's interesting here is you can see, for example, in terms of funding, 2017-18, the Commonwealth Government provided $6.8 billion in housing and homelessness assistance. So it's not an insignificant amount, but when you compare it to the amounts that have been devoted to education and health, maybe another big ticket item for Commonwealth's defence, for example, in a totally different area. This is not a huge amount, but it is a significant contribution in recognition that there are a not insignificant proportion of Australians in need of housing assistance. But the assistance is there and it's being dealt with, as you can see, discussion there about the relationship between the Commonwealth and the states with regard to the Commonwealth is more involved from a policy point of view and funding allocation. The states are more involved with ministering and sort of working out how best to do this. But the reality is that the problem is still there. It's not actually going away. And this is another big issue, of course, is that governments tend to throw money at things and they indicate, well, we're doing something, we're putting money in, we're creating programs, or we're doing this, but nothing actually much changes. And this is particularly true with regard to the Indigenous sector. And some of the housing circumstances of Indigenous Australians are very, very challenging outside of major areas. And the amount of financing, the amount of policy work that's being done in this space still doesn't seem to find a way to appropriately work out how to get out of the quagmire, if you like. So just be aware of that. So I'll just stop screen sharing that. And right, so I'm just going to go back to the slides. And I'm just going to move on now. I need to, moving on. We're focusing on Queensland now. I'm just going to refer, that was the strategy that when I did the notes, like earlier in the year, that the 2020 strategy was still relevant, but I want to just bring to your attention the more recent strategy in a moment. Different approaches in other jurisdictions. So again, thinking about policy options, good to see what's happening in other jurisdictions. New South Wales, there's been a vesting of title to public housing properties under legislative provisions, actually, in amendments to the legislation there. And there's discussion of that in the notes. A debenture strategy, which is sort of similar to a mortgage arrangement, but not exactly, in South Australia, again, with regard to trying to provide funding into the process. Victoria used a common equity strategy where there was contributions from different sources to lead to, in some circumstances, co-ownership possibilities. Co-ownership possibilities is also something explored by other jurisdictions, again, to confront the housing affordability issue in terms of moving people in the direction of home ownership where they can't afford to buy outright themselves, even if we're talking about former public housing properties. So I just want to now show you the, just bear with me for a moment. Right, so I want to show you is, okay, so here we go. So this is the current strategy of the Queensland Government, Queensland Housing Strategy 2017 to 2027. Again, very important to be aware of current strategy in terms of policy developments. And if we come down, you can see there's a bit of an infographic for us in terms of the projections. So 4,500 social homes, Queensland's referring to it, about 1,000 affordable homes and different distinction there. Focus on young opportunities for young people, and timelines of expenditure and how that's going to work over the duration of the policy. Bit of a focus on affordable housing, as you can see, as emerging out of what was just social housing, community housing. And you can see there different explanations of homelessness, social housing, affordable rental, private market rental housing and housing supply. And this is interesting, looking at partnerships, private sector, non-government sector. Again, of course, this is a policy document. It's promoting that we're doing great things in Queensland. Not that, you know, every government will do that in their policy documents and their, you know, sort of strategies. This is going to address all the issues. It's going to tackle all the challenges, and it's going to provide solutions for Queenslanders. Well, we hope it does, but history teaches us that the more things change, the more they remain the same. But governments have to be doing things and be seen to be doing things. It doesn't deny the work that's being done by government officers and government agencies, but things need to improve over time. But we also need to be realistic about what's possible and what will be achieved. So, the focus is always on more and stronger and better, and you just need to read between the lines in terms of these documents. But just have an understanding of this document. There's also a focus on Indigenous Australians. Interesting, home ownership becoming a reality for Indigenous Australians. The opportunity to buy social housing in discrete communities under a 99-year lease. That's interesting, isn't it? 99-year lease. How do you buy a 99-year lease? I thought if you're in a lease situation, you're a lessee. You're not actually having the fee simple ownership. So important to read the detail, folks. Okay, but the truth is, of course, a 99-year lease is a very significant lease, and leasehold interest, very different to, in the private rental market where 6-month, 12-month residential tenancy agreements are offered most typically by real estate agents. So just be aware of these developments and innovations that are relevant in the Queensland context with regard to Queensland government policy that's current. Right, stop screen sharing that. Go back to the slides. It's just a bit more on the previous strategy of 2020. We'll skip that. So I've already referred to the regulatory structure in Queensland, so that's important to be aware of that. I might just go back to something that, with regard to the regulatory structure, you will, I'll put a copy of this up on the website for you, that there is an annual performance review of the National Regulatory System for Community Housing. We have a 2018-2019 report on that website, and just giving a look at how things have happened and the landscape of regulatory performance. From this, again, remember, this is from the regulator's perspective. Okay, they've sought data, they've got information, but this is the response they're producing their own annual report. I'm not suggesting it's biased, but it is from, I'm just saying one needs to appreciate that it's from the perspective of the regulator. Just like when you read a government document about government policy, it's from the perspective by government, written by government, which are suggesting they're doing what they need to do as a government of the day. Quite often, if you get an independent review, then the story is a bit different. Okay, so just be aware of that. And so you can have a look at that, which I'll put up on the Moodle website for you. Right. Go back to the slides again. So we've got this regulatory system now under the national arrangements, and also we've got what's going on in Queensland. So just lastly, important to acknowledge that the arrangement between the social housing landlord, most typically today the community housing organisation, and the tenant is subject to a residential tenancy agreement so that the rights of the tenant are protected and the responsibilities of the social housing landlord are protected. Now, in some jurisdictions, New South Wales is an example of this, the Residential Tenancy Act has been amended to incorporate a section dealing with social housing residential tenancies. After a review was undertaken, appreciating that, well, social housing is a bit different to regular private rental housing, and in the residential tenancy situation, the idea of what are the landlord's rights, you know, in circumstances of non-payment of rent and so forth, and what remedies are available. You know, if a landlord, if a social housing landlord exercises a right to terminate the residential tenancy agreement and to remove the tenant, if you're talking about a social housing situation, there is nowhere else for the tenant to go. Okay, there's nothing left. So that's not to say that there might not be circumstances that might not justify that. One of the issues that's arisen in recent times is around regulations concerning social behaviour, and if there is extreme versions of that, then that's, yes, a justifiable ground to remove a tenant if that's you know, within what's possible. So just needing to understand that in Queensland, this is all part of the One Act, and it's the residential tenancy and rooming legislation, rooming accommodation legislation, which is actually covering more than just residential tenancies, but it's also covering these rooming accommodation situations, shared accommodation situations, and so on. And you can just have a look at that Act to see its parameters and how it goes about dealing with that situation. But it's not, it's got a separate area dealing with social housing tenancies like some legislation does. And again, the disputes are taken before the QCAT, Queensland Civil and Administrative Tribunal, which is again is not trying to be more informal in dealing with disputes, and it's also important to recognise that the Property Law Act does not apply to residential tenancy agreements which come within the confines of the Act. So we're not talking about general law leases here, as we were in topic 7. We're talking about residential tenancy agreements under specific legislation dealing with that situation. And this is relevant in the community housing context between the social housing landlord and their tenant. Do provide a certain basis upon which the accommodation is being offered. Okay. Right, so what we've looked at, we've had a look in this lecture at the background of social housing. We've looked at the history, where it emerged from. We've looked at what do we mean by community housing as part of the social housing context. We've seen that there is involvement of the Commonwealth and of the state government of Queensland. We see that there's legislative structures coming from the Commonwealth and also from Queensland. We've seen there's a national structure as a result of agreements between states and territories with regard to community housing, which has been embedded in legislation in Queensland, the Housing Act. And we've got a national structure, an actual regulatory structure that also involves jurisdictional-based registrars. In Queensland, we have a registrar dealing with regulation of community housing in Queensland. And then we've seen lastly that the arrangement between the landlord and the tenant is subject to residential tenancy agreements under state residential tenancy legislation. Right, so social housing, community housing, and then the evolution of a focus more on affordable housing is not a typical topic within land law, but it is, in my view, a very important area in terms of thinking about the needs of those who are economically and socially disadvantaged and how the legal structures have responded to that, dealing with the property rights of both landlords and tenants. This picture's a bit more complicated because it involves often, or historically has involved, state-owned properties. There's been funding from the Commonwealth, administration from state agencies, state housing agencies, management by community housing organisations that are not-for-profit and community-based. Developments have occurred over time that have allowed different forms of access and rights by those participants. And more recently, there have been moves to find ways to both allow tenants to have more choice in the style of dwellings that are available, and also in some circumstances and in some areas, opportunities potentially to move towards ownership options, not necessarily outright, but in some situations. There have also been developments in some jurisdictions where community housing organisations can actually acquire title in properties, most typically purchasing those properties from governments of the day. That's public housing properties, state-owned properties, where they then become the title owner, and there's a mortgage situation that's put in place with regard to those purchases. Developments to try to leverage more finance into the sector. But as you've seen from the statistics, this continues to be a challenging space, and it continues to be an area that for a significant number of Australians, the arrangements are important because they can't access private ownership of dwellings. They can't, and sometimes challenged to access private rental accommodation options. And so this is an important area. It's an important area in terms of thinking about the role of property law, but in my view, it's also an area that is in need of property law expertise from lawyers in different and various ways, both from a practice point of view, from a policy point of view, and just involvement in the sector. So, yeah, this is an important area that in my view, needs to have an awareness and an understanding by property lawyers in terms of the legal arrangements, but also in terms of opportunities for involvement. So there we are, folks. Social, community and affordable housing, topic 8, all done. And we move on in topic 9 to the next area, which is easements, in the next lecture. So until then, it's good night, it's goodbye from him, and it's good night from me. Bye for now.